Maybe it's a mistake. But the other question would be, suppose, can these rules be challenged? I think they can be challenged. If they had a supra-constitutional effect, they can't be challenged. Suppose suppose tomorrow I refuse to fix any bench. What will compel me? At the moment there is stay order of reason, I said, nahin, hum chutti pe jaate hain, hum court hi nahi lagate hain. What will you do? Move a reference against me, that's about all. You can't compel me under any law to do that. So the object is, there has been a problem, there has been successive addition of cases. We are completely closing our eyes to it. हम 2019 में full court meeting हुई थी. वो भी हम नहीं कॉल कर सकते, वो भी इख्तियार चीफ जस्टिस का है। 2019 से 4 साल गुजर गए हैं, क्यों नहीं मीटिंग कॉल हो रही है? 2019 से उस जमाने में 40,000 केसेस थे, अब उसमें ऐड हो गए 27,000। हमारी मर्जी, हमारा डोमेस्टिक अफेयर है? नहीं, हमारा डोमेस्टिक अफेयर है, पर हम तनख्वाह नहीं लें स्टेट से। हम जब टैक्स पेयर हमें पैसे देता है, हमें एक काम के लिए पैसे देता है, केस का फैसला करो, ये हमारा काम है और कोई काम नहीं है, बाकी सारे हमारे पेरिफेरल काम है। तो ये आप इतने आप उस मेन पॉइंट पे आप नहीं रह रहे हैं, आप भी खिसक रहे हैं उधर, वो भी मेन पॉइंट पे नहीं आ रहे हैं।
My lord, I just rephrase
Constitution of benches का,
जी,
इसको पढ़े ना, ये save as otherwise provided by law।
जी, so
तब तो कोई लॉ था नहीं
जी, उस वक्त नहीं था, बट ये रिकग्निशन थी कि लॉ प्रोवाइड कर सकता है कुछ।
नहीं, आपसे ये अभी देखिए,
उस वक्त लॉ नहीं था।
अब ये लॉ, क्या ये आपके ख्याल में ये जो 1980 के रूल्स हैं, ये लॉ है?
My lord, these are
आपसे सिंपल, आर द 1980 रूल्स लॉ, कम विद इन द पर्व्यू ऑफ लॉ?
191 की डेफिनेशन क्या आप
Article 191?
No sir,
no,
These are the rules.
these are the rules. The language says subject to the constitution and the law, the Supreme Court will make rules.
What is the purpose of mentioning save as, and this covers under this provision?
Yes, not just this provision, it is covered under 191. This only recognizes what 191 already.
Mr. Attorney General, then you are excluding all those laws which are made under the delegated powers. You are excluding all those laws which are made under the delegation of the power by the government or the parliament. Delegated legislation.
In what context, my lord?
In the context of declaration of law. There are two primary law and the delegated law. And delegated law includes the rules.
No, we are looking at
the Supreme Court rules are not law.
We are only looking at the language of 191. We are looking at the language of 199, and we are trying to understand what is the term or what is the scope of term law as provided under 191 is.
Yes.
Now, I had taken your lordship's 199, and we are trying to understand what is the term or what is the scope of term law as provided under 191 is.
Yes.
Now, I had taken your lordship through how this provision or the pari materia provision had historically progressed, where in addition to Parliament there was a executive as well. That role was taken away, that role was eliminated, but the role of Parliament remained. And, my lord, Article 67, which provides for the regulation of the rules of procedure of the houses, there is no such
You have not
language.
You have not argued on Article 142. This is the distribution of legislative power.
Yes.
And Majlis-e-Shura Parliament shall have exclusive powers to make laws
With respect
to any matter in the federal legislative list.
Yes.
And if we go through Article 50, the legislative list with item 57, it is also related to
58.
58. Uske saath 55, sorry, 55.
Yes, it is,
and
yes.
power of all courts.
So insofar as Section 5 is concerned, it is entry 55. With respect to other provisions, it is Article 191 read with entry 58.
Article 50.
Under 55, it says enlargement of the jurisdiction of the Supreme
That's
Court
what I said, sir.
and mental powers. So it has given us more powers. I have committed a mistake. I've given you an exact example of a Himalayan mistake committed by this court, the Recordic Judge. 6.5 billion, isn't that a big enough mistake for us to understand?
That's exactly what I've submitted. Section 5 is covered under entry 55.
So you are trying to resolve that. Why? I don't know. I mean, they don't argue the case. I don't know why we're not proceeding. We love quoting American presidents. Why don't we quote the American president, which the Supreme Court of America says 20 minutes and nothing more?
My lord.
You are not, please don't take questions, you just hear them, write them
My lord,
down, whatever.
Now, my lord, I just stick to the mission that I had made in the beginning. Mr. Amir Rahman is the person who is recording the question.
Learned Attorney General.
जब आप देखें हम आज से सुबह से कोई 150 केसेस की एडिशन हो गई होगी because of this case. We can hear this case for the next month. No other work will happen in the Supreme Court. If you want this system to collapse, please proceed. Take your time. We won't interrupt. ख्वाजा साहब नाराज हो कहते हैं, अब आप नाराज हो जाएंगे, मुझे बोलने दे रहे हैं. पॉइंट्स ले हम नोट करेंगे. हम आपको सुनने के लिए बैठे हैं. आपने इतनी मोटी चीजें दी, हम पढ़ लेंगे इनको.
Now I just quickly rush through my submissions and my
question that in order 11, the use of the word law or the term law, you think it carries the same meaning as in Article 191?
yes.
Thank you.
Now, my lord, if leaving this act out of Article 191 would render part of Article 191 redundant where it says subject to law. And redundancy cannot be attributed lightly to a statute, let alone a constitutional provision. The judgments are in the paper book. My lord, there was another submission which was made with regards to field being occupied, which is to say that since the rules had been made, therefore the field stood occupied and therefore a law cannot be made. Now, that principle also does not apply because that principle is only applicable where the powers are coextensive or coterminous. Here, the Constitution specifically says that the rules shall be subject to the Constitution and the law. It can't be. So therefore, the principle of the doctrine of occupied field does not get attracted here. Now, my lord, if I may take your lordships to the individual provisions of the statute before I conclude my submissions. Section 2, my lord. Section 2, as I've already submitted, it endeavors to create more transparency, where the power has been, which was under the rules vested in the Chief Justice, has now been
Call it a sharing of the burden.
sharing of
It's
the
a
burden.
huge burden.
Yes.
Why think of it negatively? Think of it positively.
My lord.
I don't want this burden. I want to share it with my colleagues. So what?
Fantastic, my lord. That ends the matter as far
No,
as
no,
Section
as
2 is
I'm
concerned.
talking about
Absolutely.
myself.
Absolutely. Absolutely. And because what it does is.
If I don't trust them, that's the only other way. I can't trust them.
It is in this time
trust
when
them 100%.
we want the justice system to be more efficient. It actually helps. There are more minds sitting together trying to work out how to make things more efficient and transparent in order to aid the litigants who come before your lordships. And if I may say so, the primary duty and obligation of this court is under Article 185, exercising appellate jurisdiction. 184.3 is rare cases which come before you under 184.3. It is actually the appellate jurisdiction of this court which this court is duty bound to exercise. So anything and everything which advances that objective, that constitutional objective, must be supported, must be upheld. There is no fundamental right which gets offended or violated by advancing this objective. And Section 2 endeavors to do as much.
So if that was the objective, the law would again be changed if at some stage the government or the parliament decides that no, 3 judges are not enough, let's do it by ballot. So you would amend the law accordingly?
My lord, if I may.
Or let's do it, why 3 judges, why not all 17 sitting and deciding which cases go where?
My lord, if I may respond to this.
Yes, sure.
My lord, if the pendency is down to 20,000, absolutely there would be no occasion. But if it goes to 75,000, there might
Why
be.
not 10?
Zero.
But
But this is what is being sought to be addressed.
You will attend to a matter on that thing. I don't think parliamentarians, we should disparage, parliament all the time. If the situation is that there's no pendency, maybe they would have not come up with this thing. Maybe if the damage caused by various was not done, they would have not come up with this thing. So parliament doesn't operate in a vacuum. It hears, the government is part of it, opposition is part of it, all these people are part of it. They think and they produce something. Maybe not in the most perfect of things, but we have to, each legislation must be supported unless it's clear-cut violation of the ultra-violence of Constitution, fundamental rights in 184(3). Otherwise, it can be ultra-violence of Constitution 199.
And
Simple.
my lord, the power remains vested in this court.
But Mr. Attorney General, suppose there is a parliament that is elected in the next general election. On your theory, would that parliament not have the power to repeal this law?
Of course.
No. You see, you are saying this is a law
If
affecting.
it repeals it, yes.
Is that this is a law affecting, having such a salutary effect. जी पार्लियामेंट का तो पावर ही नहीं है तो ये लॉ को रिपील कर दें, या फर्ज करें अगली पार्लियामेंट आती है वो सेक्शन 2 को फारिग कर देती है, वो कहती है जी चीफ जस्टिस का पावर है वो, दैट्स गुड इनफ।
My lord,
सकती है, आपसे पूछ रहा हूँ।
जी जी।
देखिए अवान साहब मैं देखें प्लीज, मैं उनको भी रोका था और मैं आपको भी रोकूंगा। मैं कंजूस पे नहीं जाऊंगा, मैं रियलिटी पे जाऊंगा। ये कानून आ गया, अब अगली दफा कोई केस ले आएगा हम वो वाला भी देख लेंगे। मैं ओपिनियंस कभी नहीं दूंगा। आप हमारे या तो एडवाइजरी जुरिसडिक्शन इस्तेमाल कीजिए, हम ऐसे आपको ओपिनियंस नहीं देंगे। आपका काम है अपनी सरकार, अपनी गवर्नमेंट को ओपिनियन देना, हमारा काम है उसको उसकी कॉन्स्टिट्यूशनलिटी वैलिडिटी आप देखें, खत्म। हम आपके ऊपर मफरूजे नहीं डालना चाहते हैं कि क्या होगा, भाई हमें क्या पता क्या होगा, जब आएगा हम देख लेंगे। बहुत सारी चीजें आप कर लें प्लीज इस कानून पे और आगे बढ़ा लें बात को, क्योंकि हम देखिए कोर्ट आप समझ नहीं रहे हैं इसकी अहमियत। हम लोग बैठ के इधर एक कंडीशन गवर्नमेंट में बैठ रहे हैं, लोग कोई जेल में मर रहा है, किसी का केस है, मेरी तो मुझे तकलीफ हो रही है। सुबह से 57,600 कोई 57,000 है, अब हम छोड़ के जाएंगे 150 और बढ़ जाएंगे, कल 150 और बढ़, आप चला लें 1 महीना केस, हमें क्या फर्क पड़ता है? किस लिए पड़ता है? क्योंकि हम तनख्वाह ले रहे हैं इस गरीब आवाम से एक काम करने के लिए कि उनके केसेस का फैसला कर लें, खत्म। ये बहुत अच्छी डिबेट है, जाके हाई कोर्ट में कर लें चैलेंज, वो आ जाएगा जजमेंट हमारे 94 में, हम बड़े पूरे पावर्स के साथ बैठ के इशू था। इसके बावजूद के स्टे चल रहा है। मैंने अपने 2 सीनियर कलीग से पूछा कि मैं ये करने जा रहा हूँ, 2 स्टे चल रहा है, अलग बात है आइन कानून पर स्टे चल रहा है, फिर भी कि बात को आगे बढ़ा के किसी खत्म कर लेना, सराह लें कानून को, ये तर्क कर दें, मगर आप अपने दलाइल दें, हम उसका सुन लेंगे और फैसला कर लेंगे। कोई इख्तलाफ करेगा, कोई नहीं करेगा, उनकी मर्जी है। हमें आपको परसुएट करने की कोई जरूरत नहीं, आप हमें परसुएट कर लीजिए, और सवाल का जवाब नहीं देना चाहते मत दीजिए, हम आपके खिलाफ कर लेंगे फैसला।
My lord, my learned friend is question.
No, sorry. I'm not indulging in conjectures.
My lord,
I'm asking you a question in order to understand the principles that you are saying and arguing and submitting before the court. I'm not engaging in theoretical argument.
my lord,
I'm trying to understand the basis on which you are defending the
My lord,
constitutionality of this law.
आपका सवाल।
So therefore my question stands.